Good morning, everyone. We're in our second case on the Court of Appeal. Good morning, everyone. We are in the second case of our docket on the Court of Appeals this morning. The second case is Wheatland Electric Cooperative versus the City of Garden City, Kansas. I have many powers as your presiding judge, and one of them is to expand the argument if I think that it should probably be expanded as far as time limit. So I am sua sponte, which means of my own accord, going to expand the oral argument for instead of 15 minutes aside, I'm going to give you 20 minutes aside. And that's my order. The judges on your panel today are Judge Steve Hill, formerly from Miami County, now in Shawnee County, and Judge Leslie Isherwood, formerly of Sedgwick County and still in Sedgwick County, although we'd like to get her somewhere else, but she's still there, where she has maintained a home and had her professional career for many, many years. So that's your panel this morning, and we look forward to your arguments. And if the plaintiff's counsel, Mr. McKay, would tell me how much rebuttal time you want out of your 20 minutes, I'll be happy to grant it.
Your Honor, I'd like 15 minutes, and if I can reserve 5, I may not use it, but if that's okay.
Okay. You've got it. Please proceed.
Please, the court, thank you for hearing our case. Again, my name is Jim McVeigh. I represent Wheatland Electric Cooperative, Inc., who is the appellant and the plaintiff in the district court. We think our case is a very simple case of simply reading and understanding the statutes of the Retail Electric Service Act, and then applying that to the annexation code for an annexation. We believe that we've proven the elements with uncontroverted facts. We've proven the elements that we had the service territory at the time. We lost our service territory rights by annexation. When that happens, the compensation portion of KSA 661176C kicks in, and we have proven that by stipulated facts. The Retail Electric Service Act is pretty simple. It gives the commission, and I guess I want to stop at the Corporation Commission real quick and make sure that I talk about them a little bit, and that is maybe not enough in my brief or anybody's brief, but their expertise is needed under the Retail Electric Service Act. Their expertise in deciding who gets the service territory, who is assigned the service territory. They have staff, they have hearing officers, they have a whole section, for example, that keeps track of the assignment of the service territory and not only who gets the service territory, but what the actual service territory is. Under the Retail Electric Service Act, it's clear that they divide the entire state up to include cities, and outside of their city limits, they're required to comply with the division of the state. Yes, Your Honor.
Counsel, I've got a very simple question for you. 2 of them, actually. First of all, as I understand it, as the territory was created several years ago, Wheatland, your cooperative, was responsible for providing electric service to all of the areas outside of Garden City, and maybe even to a little bit of Colorado. Is that correct?
That's correct, Judge.
So if it was inside the city limits of Garden City, that was not your responsibility. But you sold electricity to Garden City for distribution within the city limits, did you not?
We were their retail electric supplier, and we had a pass-through agreement with the wholesale provider that sold to Garden City. That's correct.
All right. Now, my fundamental question to you is this. What authority did Wheatland have to cede any of its territory to Garden City?
I don't think we had any authority to cede our territory to Garden City.
Now,
I don't think we.
If that is so, the court, district court, as I understand it, found an implied in fact contract that you did that, and in fact concluded did the court not, that you ceded this territory through your actions to Garden City?
That's what the district court erroneously found, correct?
And that was based upon some sort of oral agreement between your general manager at that time and the city manager of Garden City. Is that correct?
That's what happened. That's correct.
All right. Now, was that oral agreement ever ratified by the trustees of your cooperative?
It was not, neither was it by the city commission.
And so was it ever ratified by Garden City? And it was not. Is that correct?
That's correct.
In fact, this agreement wasn't even in writing.
That's correct.
All right. Now, did Wheatland ever supply electricity to, I think it's some plant outside that was outside the city limits at the time?
No, Wheatland has never provided retail electric service to the Conestoga plant, nor any of the areas that we stipulated to that were annexed at the time of the annexations that are at issue in this case.
Can you give me an estimate? Garden City did. Can you give me an estimate what those electric costs would be annually to the Conestoga plant?
The cost to operate the Conestoga plant, or the cost to serve the Conestoga plant, or facilities to serve?
No, how much would Conestoga have to pay for electrical service annually?
Well, that is in the evidence that we submitted. It's the gross amount by Garden City was, I believe it was about $3 million for Conestoga and Petro Santander.
I think that's what I read in the record. So Garden City from this arrangement was getting receipts of $3 million. Now they had expenditures for facilities, did they not?
That's correct.
All right. And the court went into an elaborate detail about all of that.
That's correct.
But if I understand your argument, you're saying none of this matters.
That's correct.
Because what you lost when Garden City annexed was the rights to service.
That's correct. We were currently at that time in litigation in front of the commission to determine who was the one who had the right to serve those low consuming facilities, and that at the time Garden City annexed.
All right, thank you. I think that's all of I wanted to get all of those facts settled in my mind.
Yeah, and
so you proceed with your argument.
I understand completely. The right to serve the territory was bound up in the Retail Electric Service Act. You have one retail electric supplier that's assigned the entire territory. They divide the state up, period. They have the exclusive right to serve in that territory. The exclusive right to serve, then you get a certificate of convenience and necessity, which we always had. We had the certificate of convenience since 1959. Again, when the Retail Electric Service Act of 1977 was implemented, it was again reassigned to us. It's real. The Retail Electric Service Act certificate of service actually has a legal description showing you what your territory is. That in fact that was entered into evidence. They stipulated that in fact in the agency action, the 17370 docket, that service and the right to serve that this oral agreement that they're arguing should have transferred the territory to Garden City. That was being litigated at the time the Garden City territory. Again, the certificate of convenience and necessity, that is the right to serve. That is the right that we got in front of the commission with, and the right that we were litigating at the time that they annexed the territory. In fact, what answers your question here is there are only two ways that you can lose your service territory. Not by some oral understanding that they don't enforce by law, not some agreement, unwritten agreement between the two providers. The Retail Electric Service Act makes it clear in 773 that you shall not serve outside, in this case, outside of the city limits and into our service territory. And so the only way that they can serve this territory legally is under 1175 that says that if you have an oral agreement, you have any, you have to take it to the commission. You shall take it to the commission, and only if approved, will the commission then issue certificates. That never happened. In other words,
The district court was not impressed with any of that argument. In fact, using the language from the city, they said your arguments were absurd and was really negative about your position upon that. But I'm interested in knowing what the district court very elaborately in that long opinion that he wrote talked about equity. That it was a Garden City who was providing these customers with electricity, and Wheatland was not. And so they were simply claiming what they had acquired through this agreement. Can you speak to that?
Well, there's, I think, several points on the equity question, and I think it's well versed in the briefs. First of all, equity follows the law. There's a statutory scheme that states what is supposed to happen, such as getting a contract approved, and which is the only way you can cede that territory. We can't cede the territory. We have, and neither can Garden City by some agreement. Only the commission can cede that territory. That never happened. They rested on the right to have this contract approved for 15 years. They rested on the right, for example, to annex for over 15 years. They could have annexed any time before there were load consuming facilities in that territory and not paid Wheatland 1 penny. And so they rested on these rights for years. Now, what happened here is they built the facilities. You have to understand that the commission has a very special responsibility in this scenario. The commission is the one with authority that forced Wheatland to allow Garden City to use our facilities to, once we lost the right to serve in the city limits, provide retail service to the city, the commission had the right under the Sunflower Open Access Transmission Tariff, under the FERC tariff. They forced us to give them what's called last mile service. That last mile service under the oath, this was argued to the district court. He never addressed it in his brief. And this is part of the Latches argument. Relevant. Is that they were never going to be harmed. Keep in mind, Latches isn't just delay. By the way, delay caused by them, but it wasn't just delay, but delay that causes harm. And in the 1730 docket, the argument was clear. They were never going to be harmed. Even if they gave us the territory, forced us to, said that it was our territory, as the certificate of need said, Garden City was going to be paid a local access charge, and those facilities were never going to be stranded. They were always going to get paid. They were never going to be harmed by this 15 years that they waited to annex the territory, or the 15 years that they didn't go to the commission by law and get approval of this oral understanding we had. And so their argument in front of the commission was going to fail clearly for that reason. Frankly, it's the reason they annexed, because that's when the commission started asking that question. The next week is when they annexed. The annexation, the following, it makes it even a less argument, because they still have the facilities. They now have the territory. If their argument is we're harmed because we got to pay damages under the compensation statute, the argument should fail on its face. The argument that they got to pay compensation should fail because they chose that. But mainly the argument that they chose failed because they could have annexed many years before there were load consuming facilities and the territory paid zero. Under the same statute that they annexed, they could have granted Wheatland a franchise and not paid anything. They were not harmed in any way by what happened by Wheatland asserting its rights. And the underlying argument that supposedly there was a contract under equity also fails for a couple of other reasons. At no time when this oral discussion between Neil and Mr. Halloran back in 2004, 2005 happened, did Wheatland ever agree to them that, hey, if you annex that, we're not going to exercise our right to compensation? Nor was there ever discussion, and the court agreed with this, nor was there the district court, nor was there ever discussion if they later annexed And we asserted our right to compensation because of the loss of our rights to serve the territory. If you parse 66.1176 A, C, and D, there's one thing that is very clear. They use the term service rights or loss of service territory rights in 5 different places to say that is the basis of compensation. When they annexed, they made the choice. When they could have stuck it out in front of the commission, they could have said, okay, commission, you make the decision. If the commission decided to award them the service territory that they claimed they had in front of the district court, which they never had, the commission never ruled on it until their dismissal. They could have any time done that if they wanted to. However, that's not what occurred.
Counsel, Garden City moved the commission to dismiss your complaint, correct?
That's correct.
And what was Wheatland's position on that motion to dismiss?
The Wheatland's position was clear that under the law, and especially under the Lion Coffee case, we no longer, once the annexation is effective, it's within this, that territory is within the city limits. It's no longer in our certificate, period, by law. It is purely a matter of when the annexation is effective and 180 days pass. That's it.
Counsel, that remedy was available to Garden City 15 years prior, correct?
Correct. When that happened and 180 days passed, we no longer had the right to make the motion under the complaint that we were under, the application complaint we made. It was no longer our territory. And therefore, that we lost our service territory rights that was being litigated in front of the commission, and the commission never made the decision who had it. Now, here's what's interesting about that point. In the commission dismissal, Garden City also agreed that when they filed their notice of annexations, these exact 3 areas by legal description, they asked the commission to put them in their, to acknowledge that it now was within their certificate of convenience, which the commission had no right not to do. It was purely a ministerial act. Once it's effective, 180 days pass, they give them the notice of annexation. It's in the city limits. We no longer had any rights to it whatsoever. And that's why we took the position that was legally correct. We had no right to serve the territory, and we had no right to ask for the relief in that docket anymore.
All right, Mr. McVeigh, I'll give you 30 seconds to wrap up on your first argument.
The only other thing I wanted to point out is the equity arguments that equity follows the law. I think it's clear that when there's a statutory scheme and that statute says you must do such and such, and that is in this case, get a contract approved to change service territory, that they have an obligation to do that and never did that. Then when they did do that and the 1730 docket, they then lost their nerve and they then annexed the territory. When the annex happened, it was over. They can't then go to the district court. They didn't exhaust their remedy. They can't go to the district court and say, hey, we now have the service territory. They didn't have the service territory. Wheatland still had the service territory until the minute the annexation was effective. Thank you.
Thank you. Mr. Sear, you have 20 minutes, sir.
Good morning, Your Honors. Tim Sear on behalf of the City of Garden City. First of all, let's be clear. There can be no doubt that the district judge got it exactly right when he found that there was an implied, in fact, contract between the city and Wheatland. And how do we know that?
Counsel, let me ask you something. In order to have an implied, in fact, contract, you have to have something that you can legitimately trade. What authority did Wheatland have to cede any of that territory to Garden City?
Your Honor, that power is specifically addressed in KSA 66.1,175, which explicitly gives a utility like Wheatland the power to enter into agreements to redraw its boundary to allow a neighboring utility, or in this case, like the city, to serve what would otherwise be in Wheatland's territory or their customers.
But that
The
agreement
statute-
must be approved. That agreement must be approved by the commission, does it not?
Your Honor, the statute says any agreement entered into pursuant to this section shall be subject to approval by the commission. However, as we note in our briefing, that there are myriad Kansas appellate cases holding that shall oftentimes means may.
So your argument is that this informal arrangement between a general manager and the city manager nullifies that particular statute because it was in a practice and everything's fine. So the KCC had no authority to do anything. You don't need to approve that. Is that correct?
Your Honor, that's not our argument. Our argument is that the implied in fact agreement that the court found fits the kind of agreement that's referenced in 1,175, and that although both parties failed to get KCC approval for that.
Well, they didn't even seek it. You didn't even get approval from the city fathers or from the trustees. This is just an accommodation between two men. How can you say that's a valid contract?
Your Honor, first of all, Wheatland never claimed that there wasn't a valid agreement or that either Wheatland or the city was without authority to enter into this implied in fact agreement. So
but you represent the city and you know how cities are bound, and you have to have ratification, do you not, of the governing body in order to bind the city, don't you? And you didn't have that here.
I don't think that's a correct statement of Kansas law. Cities and counties and all sorts of other public entities end up binding themselves by their conduct without regard to whether, for example, there was a resolution introduced at the city council and passed.
So you're arguing then this oral agreement, this oral arrangement bound the city of Garden City without the city government taking any action whatsoever.
Yes, we took upon ourselves the responsibility to serve these customers as a result of the agreement reached between the city manager and the general manager. And
do you agree with your opposing counsel that you were receiving about $3 million a year in income from the sale of electricity to this plant? Is that figure accurate?
Your Honor, I don't have that right in front of me, but it certainly would have been in that ballpark, although that's gross receipts.
Yeah, I understand that. Yeah.
And out of the money that was received relative to this arrangement, Wheatland obtained profits of approximately $1.8 million that it would never have received but for this agreement. That is, the record is clear that if the city and Wheatland had not entered into this agreement, the ethanol plant would have never located to this area. Wheatland would have never supplied at wholesale the power for that facility, and those jobs would not have located. So everyone acknowledges that this agreement resulted in benefit to the city, benefit to Wheatland, and benefit to the customers.
My question to you then is, if that is so, what difference, because your opponent is arguing, so what? We have this right to this territory. We didn't cede it by this oral agreement. And you, as the city, had the right to annex, and you did. And the statute says if you annex, you pay for the rights. Now, what's your response to that, if you could, please?
Your Honor, if we dig into the compensation statute, 66 1,176, I'll demonstrate how the statute cannot be applied to this situation. First of all, there's no doubt that the purpose of this statute is to compensate a utility for loss of its customers and the revenue that would have been obtained from those customers.
You equate this then with the potential, with the rights then, not actual revenues, or are you arguing actual revenues?
No, it's got to be actual revenues because there's a 12-month look back prior to the transfer of service. So that's
the measurement. I mean, you've got to use that to measure.
Correct. But it's, you look back for the revenues from those customers for the 12 months prior to the transfer of service. That's the language of the statute under subsection C.
There are other ways to do it. There are other ways to measure those damages as well in the statute, but they don't pertain to this case, do they?
Well, Your Honor, they do pertain to this case, although the number would be 0 for some of these categories. So let me explain. First of all, the subsection C measure of 2 times revenues for the 12 months of customer receipts prior to the transfer of service has to be 0 in this case because there was no transfer of service from Wheatland to the city. These customers were never served by Wheatland. That's an undisputed fact. So when the 2 times gross revenues analysis is made, it's 12 months prior to the transfer of service, and there was no transfer of service on the date of annexation or at any other time. Because for there to be a transfer of service, there has to be a customer of Wheatland that is now being served by the city as a result of the annexation. That could not have happened in this case because the customer was never served by Wheatland, so there was no transfer of service. Now, no matter what Wheatland wants to say about that, that's the fact, and that's what the judge mentioned, the district judge, in summing up in this case, that if it was never your customer, then there isn't a loss to you by someone else serving the customer. And in this case, the city always served these customers and never Wheatland. Now, Judge Hill, what you referenced about the other subsections for damages also demonstrate that Wheatland cannot make a claim under the 66 1,176. And let me explain why that's true. Under 176 sub A, the statute states that the terminated electric supplier's right to provide service, electric service, terminates 180 days after the date of annexation. Okay? Wheatland cannot satisfy that condition because they were not providing electric service prior to or on the date of annexation, so they weren't in a position.
Counsel, I thought you used the term right, the right to serve.
Correct, that's what the statute says.
Well, what does that mean then? What does that mean? It is the right to serve? Isn't that what's being lost here, is the right to serve?
Wheatland did not have the ability to serve during the 180 days
Well,
after
you're changing the word. The right to serve. Isn't that what is lost? Was Wheatland lost was the right to serve? Not whether it was serving or not, because I don't think that's disputed.
Under the Retail Electric Service Act, you cannot separate the right of the utility from to serve and the responsibility of the utility to serve. When the agreement was entered into between these parties, the right and the responsibility was transferred from Wheatland to the city.
And when was that? When the plant was built, or when the informal agreement was, or 5 years into it? When was that? When did that transfer take place?
Well, it certainly started in the 2004 and 5 timeframe when these discussions occurred. And it certainly continued in December of 2007 when the city connected to the Conestoga plant. And it continued for 10 years thereafter without dispute.
To answer my question then, did the district court find, as of this particular date, Wheatland ceded this territory to, because I think the district court used that language, ceded this territory to Garden City?
I believe that's what the district court said. I'm not sure that I can tell you that the judge said as of a certain date, but the judge did refer to the uncontroverted facts that even after December 2007, when the city began serving the ethanol plant, there were multiple occasions thereafter when nearby additional customers contacted the city and contacted Wheatland about who was to serve. Wheatland told these customers the city would be who is going to serve you. So this district court ruled on contract principles, not on equitable principles on that particular point. That's correct. Although the district court did point out that to the extent that Wheatland was claiming at this late date that they could attack the arrangement or the agreement, that Wheatland was barred by estoppel, latches, and other equitable defenses from taking that position, that it would be inequitable at this late date.
And that agreement was enforceable even though it had never been approved by the Kansas Corporation Commission.
That's correct, Your Honor. And I would note.
Can I ask a question real quick? I am troubled, Mr. Spear, by what analytical framework it is you're wanting us to use in an effort to resolve your claim. Because the city seems to have applied a smorgasbord approach to RISA from the time of this oral arrangement and wants us to give full force and effect to the plain language of the statutes that only benefit the city. And that's not how this act works. We have to consider all provisions together for a reasonable result, not just those that benefit the outcome to you. So please help me understand what provisions of this act we are to give force and effect, and which of those are merely advisory.
Okay, Your Honor, clearly, if KSA 661176 does not apply, or if the formula results in a series of zeros, then Wheatland is entitled to nothing. And we agree that these statutes must be read in para materia to come up with a reasonable analysis that incorporates as best we can all of the different subsections and items within this statute.
And if we do that, don't we then also have to give force and effect to the numerous times throughout this act where it specifically states agreements of the nature that you guys entered into back in 2004, 2005 were required to be approved by the commission. Aren't we then also required, if we're going to read them together as binding language, why is that not binding language?
Okay, Your Honor, as I've mentioned, the shall in 661175, we believe under a proper analysis should be read to be may.
Because
And
it's a
let me-
benefit to the city?
I'm sorry.
Because it benefits the city's position. So is that true for the remainder of the act, that anytime the legislature chose to insert the word shall, it's merely advisory?
No, Your Honor, it's because what the commission's role would be where there's agreement reached between Wheatland and the city and benefits the customers, there is no reason to believe that the KCC would not approve such an arrangement, number one, and Wheatland does not claim otherwise. And second of all, the role of the KCC in this regard is ministerial, which is also what Wheatland has said, and is a bookkeeping arrangement. So
Where
isn't
is the benefit to the customer versus the financial and economic benefit to the city?
the parties agreed that the uncontroverted facts were that Conestoga would not have located to this area if Wheatland was going to be the electric supplier. So that's the benefit to Conestoga. And Conestoga insisted that the area not be annexed for a period of 10 years because of their financial arrangements.
And I understand all of that. I've read the record, but why not formalize that agreement?
Your Honor, that agreement could have been formalized, and at best for Wheatland, the parties were equally at fault, but under my analysis, Wheatland was more at fault because Wheatland was the entity regulated by the KCC, not the city. So
right, I got a question, and it has to do with the meaning of the word shall in this sentence on 1175. Any agreement entered into pursuant to this section shall be subject to approval by the Corporation Commission. If so approved, the Commission shall issue certificates accordingly. Now, as I understand, the Wheatland's position is that the word shall means mandatory, must. And as I understand Garden City's position is that shall means not mandatory. It's merely ministerial. If the court finds that the word shall means mandatory, does that mean that this contract is void or voidable?
Your Honor, if the court would go that route and find that the contract is void or voidable or illegal, that still does not mean that Wheatland prevails. And that's because of long standing Kansas case law that if parties, that's the Sider versus Alvey case, that if the parties are equally at fault and enter into an arrangement that is illegal, void, or voidable, but is no longer executory, the court leaves the parties where they are and does not award money to either side.
All right,
And
but in answer to that, and that may be absolutely true, but in answer to my question, if the court decides that shall is a mandatory shall, do you agree with me that this contract is void or voidable?
Your Honor, it may be void or voidable in that situation, but you still can't fill in anything other than zeros under the compensation statute, because even if the contract is void or voidable, Wheatland cannot satisfy the factual predicates of each of the subsections. That is, they were not providing service at the date of annexation, so there was no date of transfer of service. Second of all, if they were the party to be compensated under 1176, they would have rights to continue to serve after the date of annexation, and that can't apply to them because they never even had the ability to serve. It's an undisputed fact that even if Wheatland would have tried to serve these customers, there would have been a lag time of over 6 months, and it would have cost them over $1 million to put the infrastructure in. So they weren't serving on the date of annexation. These weren't their customers. They weren't their facilities being used, and there was to be no disconnect from Wheatland's facilities to these customers that they would be compensated for under the statute. So there is nothing under the compensation statute, factual predicates, that can lead to the conclusion that whether there was an agreement or not, whether it was void, voidable, or illegal, they don't qualify for compensation because they didn't lose the use of their facilities. They didn't have to go to the expense of disconnecting from these customers because they'd never been connected to the customers, and they had never served these customers such that there could be a date of transfer of service.
Other than the plain language of the statute that says service rights. And they still held the certificate to that territory because it was only an oral agreement, and those service rights are what is attached to that certificate. It does not say customers. It says service rights.
It says, Your Honor, service rights in part of the statute, and uses the term transfer of service, not transfer of service rights, under the compensation part that they claim is the only subsection applicable. It doesn't say the customer revenues for the 12 months preceding the date of transfer of service rights. It says 12 months preceding the date of transfer. Your Honors, it simply would be a gross windfall and miscarriage of justice to determine that both parties were equally at fault for failing to get KCC approval, an approval which no one claims would not be given, and that the penalty for that is only to be assessed against the city and its citizens to the tune of $7 million, when it is undisputed that if not for the implied in fact agreement, there would have been no customers in this territory, and
Counsel?
Wheatland would not have received the $1.8 million that it received in profits.
Counsel, you could have brought all of this up in front of the KCC, but stopped and annexed. It seems to me that the city made a choice. We're going to annex. And so all of this that could have been brought up in front of the KCC, in fact, it looked to me in reading through the record, that's exactly where that was headed, and have all of the expertise of the Corporation Commission and its staff in there. But the city decided to annex. And once that's done, this statute applies, does it not?
The statute applies only to the extent that the annexation is the event that causes the transfer of service. In this case, the
statute doesn't say that.
Well, Your Honor, the only compensation provision that the Wheatland claims is applicable, the 2 times gross revenues, does say transfer of service. It does not say transfer of service rights. The legislature must be presumed to have meant something by saying service rights in other parts of the statute, but only transfer of service in this compensation provision. And it's undoubted, Your Honors, that there is no reason to give compensation to Wheatland if they didn't lose any customers.
All right, Mr. Sear, you're well past your time, so we're going to have to cut you off. Unless the panel has any other questions for Mr. Sear. I see none. Mr. McVeigh, I'm going to give you an extra 2 minutes on your 5, but make sure it's within 7, or else I'm really going to lower the boom on you. So you may have your rebuttal argument.
David, please report. Mr. Sear keeps talking about the provision that only says transfer of the service. That's actually not what the statute says. The statute actually, after it talks about whenever service rights of a retail electric supplier are terminated pursuant to subsection A, fair and reasonable compensation shall be paid, and then the sum of the 4 elements. In other words, Wheatland doesn't have to have all 4, just the sum of those 4. Then it says what those 4 are, and you get to 3. An amount equal to 2 times the gross revenues attributable to the customers in the terminated territory during the 12 months next preceding the date of transfer of the service pursuant to subsection A. Every time Mr. Sear argued transfer of service didn't apply, it must apply to customers, he left out the end of that statutory language that says pursuant to subsection A. Under subsection A, it is remarkably consistent, just like the rest of the statute, that the transfer of service is the transfer of service right. Whenever a city proposes to annex land that is located within the certified territory of a retail electric supplier, then it goes on to about providing notice. The second sentence, all rights of a retail electric supplier to provide electric service in an annexed area, unless such electric by a city shall terminate 180 days after the date of annexation. Again, it's talking about service rights being lost, and it's under the compensation provision pursuant to subsection A. Under subsection A, there's only one other thing that could be a transfer of service, is the final sentence when the commission then certifies that territory to the other supplier. The last sentence, in the event service rights are terminated pursuant to this section, the commission shall certify such annex area as a single certified territory to the supplier holding a franchise for or then providing retail electric service immediately within the city limit prior. So again, it is clear that the loss of that is being compensated under 3 pursuant to subsection A is the loss of our service territory rights. It doesn't stop with transfer of service. It doesn't say anything about customers. It doesn't say 3 under an amount equal to 2 times the gross revenues if you were serving retail to customers in that territory attributable to those customers. It doesn't say anything like that. It doesn't say only if serving those customers and it's terminated. It very specifically refers to subsection A, and I believe that this statute's highly consistent. Yes, sir.
Counsel, I have a fundamental question for you. What are you asking of this court on behalf of Wheatland?
Yes, sir. I'm asking this court to do what I believe the uncontroverted facts are. We had the service territory. We had the rights to the service territory. It was never changed under 1175. And therefore, at the time of annexation, you apply 1176, and 1176 basically says that if you lose your service territory rights, which we believe we've proven we did by annexation, we've proven the numbers under C3 of what the 12 months preceding the gross revenue. Those are by stipulation by council. We know what the number is. We know what these 2 numbers are. The only thing that I think is up for you to decide under this is what is the date of that transfer of service pursuant to subsection A. I believe it's clear. I believe the second sentence that says 180 days after the effective date of annexation is when we lose our service territory rights. I think that the last sentence is a ministerial act. I think that where it says in the event the service rights are terminated pursuant to this section, the commission shall certify the annexed area to that other supplier. I believe that date, even though I gave you the numbers for both dates, and they're stipulated in the record, I believe that the first, even though it's a smaller number, I believe that first, the second sentence in that paragraph, subsection A, controls.
So are you asking us simply to reverse the district court and enter summary judgment on behalf of Wheatland?
That's correct. That's what my pleading says. That's what my request is in my brief. And now I understand that there may be some cleanup issues. We also asked for prejudgment interest. We think that prejudgment interest should have been, and I because of the page limitations, I didn't address it other than to adopt by reference that discussion and that movement in our motion in front of the district court. But there may be some cleanup items like that, but every fact necessary to prove the elements for giving Wheatland compensation under the statute are demonstrated and proven. That's all I have, Your Honor. Thank you.
All right.
If there are no more questions.
Mr. McVeigh, thank you very much. Mr. Sear, appreciate your arguments both, and we'll take the matter under advisement and issue an opinion.